An official welcome to everybody to our Gilfix webinar, why the structure of your trust might be wrong. If you have a living trust or an estate plan that was set up a few years ago or even recently, you need to understand the structure of your trust and if it's right for you and for your family. That's what we're here to talk about. And this is going to cover everything. It's going to cover some critical tax issues as it relates to your trust. Taxes aren't everything, but we're going to make sure that you understand, at least at a high level, why it's so important to have the right trust structure and why a living trust is not enough. So as we jump in, I want to just ask you why you joined us here today. We really appreciate it. Do you feel just confused or overwhelmed about estate and tax planning issues? The focus is on controlling what you can control. We're going to go through critical trust concepts to protect your assets and really to protect your family and everything you worked for. And as we get started, I think it's important to understand the context in which we are discussing these issues. You might have missed it, but we just had an election pretty recently, and it looks like we have a split government. We have a Democratic president, we have a Democratic-controlled Senate, and we will almost certainly have a Republican-controlled House. What does that mean? Well, it means probably we're going to have gridlock, and this matters for your trust structure from a tax standpoint. So now let's go through what we're going to cover here today. And Mike, why don't you lead us through that?
Sure. So we're going to make sure you're familiar with what a trust is, who are the players, what are the roles that people play when you set up a trust. The AB trust is something that most couples have. Until a few years ago, you really had to use that approach. So we're going to talk about what it means, what the options are, pros and cons, what the benefits might be of changing to a different structure. Certainly talking about why a living trust is not enough. A living trust is fundamental. It doesn't do a lot of creative planning. So if we're thinking about protecting multiple generations, we'll certainly offer some alternatives, some ideas that'll be very productive, that are extremely powerful. So, and we always end, of course, or Mark will end with action steps. What do you do with all this information? That's the key.
And we always have to point out this is for educational purposes only. It's not official legal advice. It doesn't create an attorney-client relationship. We have to meet with you and actually work with you one-on-one to do that. So we're here just to empower you with knowledge and spread the word. Take what you've learned. Let your friends know. You're going to have a lot of information. You're going to be ahead of 99% of the population after you watch this. And really quickly, for those of you who don't know us, so first of all, welcome to our incredible clients. We love our client community. If you don't know us, we are Gilfix and the Pole Associates based in Palo Alto, California. We serve clients throughout the state of California. We've been around for over 40 years. We are very proud of our heritage and our history as national leaders. We write about this. We think about this. We've been featured in the national media. We work with thousands of California families, and it's our mission to educate, empower, and really help families, no matter what that means, to provide extraordinary return on investment and peace of mind. That's what we're all about. As we jump in, we're going to go through some mysteries. A tale of fixing a trust. Larry and Susan have a $3 million estate. Sounds like a big number, but that includes the value of their house. So in many parts of California, you own a house, you have a $3 million estate. Susan outlives Larry by 5 years. Their estate grows to about $5 million in that time because the value of their house grows, some stock values grow. When they pass away, their children face over $300,000 in capital gains tax exposure. Wyatt and Jane, same situation, same numbers, but when they pass away, their children face zero capital gains tax exposure. Missing an X thing. When they inherit, what is the mystery here? Let's talk about a large estate.
So a larger estate. So here we have a couple, Ben and Ann, and they have a $10 million estate currently. It's going to grow. We're optimistic about the stock market long-term. Real property, it never stops growing. So their estate is going to grow over time. Their estate is going to face over $1 million in estate taxes. Okay, Jacob and Sarah, same estate, same values, same growth. Upon their passing, zero estate tax exposure. What's the difference? What's the mystery? We will revisit.
And lastly, a tale of supercharging a plan, Larry versus Wyatt. Larry's father leaves him $2 million for his benefit. Larry gets divorced. He endures a lawsuit. When he passes away, that $2 million is gone. Nothing's there for his children, and certainly nothing there for his grandchildren. Wyatt, same situation, $2 million left for his benefit. there's a difference in how it was left for him. And when Wyatt passes away, even though he endures the same divorce and lawsuit that Larry did, they lived basically the same lives. His children end up with $6 million. And when they pass away, there's $18 million there for his grandchildren. What is the difference? What were the differences in planning steps that Larry's family took or didn't take versus what Wyatt's family took to create this $18 million difference over 2 generations? We're going to reveal these, and let's go over at a high level trusts, what they are. Mike, why don't you talk about trusts?
Okay, so you probably have a living trust, a revocable trust. By the way, the term, you can call it anything. You could call it the Schmaltz trust. I mean, it's what the contents of the document say. So the trust that I set up for my family, that you set up for yours, it's a revocable trust. It has all kinds of benefits. And I think Mark will go through those in a few minutes. Your trust is revocable. You can change it anytime you want. You can do anything with it. You're in complete control. Revocable trust. Now, the other broad category would be irrevocable trusts or irrevocable trusts, depending on what part of the country you're from. Okay, so irrevocable trust. It's a trust you cannot amend after you set it up. Everybody, if you have any assets at all, you should have a revocable living trust for a host of reasons, management, probate, a host of reasons. Irrevocable trust. So what does it even mean? You know, again, it's a trust that you can't change. The terms cannot be modified. In our office alone, we probably do a dozen different types of irrevocable trusts. We sometimes have questions or hear somebody saying, well, gee, I was told by my lawyer I need an irrevocable trust. Okay, what does that mean? It is sometimes appropriate when we're doing more sophisticated tax planning. We sometimes utilize that when we're looking at asset protection and long-term care. So there's many different approaches that can be taken. But again, the major point for the day is our focus is on revocable living trust, your basic document, realizing again that there are irrevocable trusts that could come into play. And in fact, with the Dynasty trust approach that we think is so vital, Mark will talk about that a little bit later. So there's your brutal overview of revocable and irrevocable trusts.
Yeah, I was talking to Mike earlier because people say I need an irrevocable trust. That's like saying I need a car. Okay, is it an SUV? Is it a sports car? Is it a truck? You know, there's a million different subtypes of these trusts. But let's talk about, just for those of you not familiar with this might be revisiting this issue. But if you're not sure, why do I need a trust? Well, think of this as replacing a will. So I think everybody's familiar with what a will is. A will, you say I leave everything to my kids and that's it. A will can make sure that your assets go generally where you want them to go. The problem, though, is wills, if you just have a will, if you have any assets at all, it means your assets are going to be stuck in something called probate. It means it's stuck in the California court system for up to like 2 to 3 years before assets get to your family. It's a painful, slow, expensive public process. So when you see celebrities who pass away and you see everything about their estates in the news, it's usually because well, either they didn't have an estate plan or they just had a simple will. So everything is public. A will also doesn't help you when you're alive. If you become incapacitated or sick or out of it, the executor of your will has no role to play. They can't do anything until you're gone. So a will doesn't help you while you're alive, and it sticks your family in the court system for a long time. And it's very expensive, by the way. The fees can be double or even triple that of administering a trust. Now, a trust, on the other hand, keeps your assets out of the courts. Over time, they save a lot of money because your family doesn't face those court fees. Not public. Nobody gets to see what's happening. And it helps you while you're alive. You get to name successor trustees who can step in to help manage your estate if you become incapacitated. So let's talk about, so no brainer, you need a living trust. If you don't have one, we can help you set one up. If it's been a long time since you looked at it, well, that's what this talk is about. Now, let's just revisit some high level terms that you should probably be familiar with when it comes to trust. And Mike, why don't you lead us through that?
Sure. And by the way, if you have any questions or if you'd like to give us information about how to contact you for follow-up, you can do that in the Q&A function. So it pops up and we will review them. I have to leave before the end of the webinar, so Mark would deal with that at the end. But we welcome questions. And again, names and contact information if you'd like us to follow up. Okay, so here again is the revocable trust. And, you know, there's so much terminology that it gets very confusing. when I first learned about trust, I didn't know what the heck a settlor was. I thought it made no sense. Okay. So the settlor, that's you, that's me. We're the ones who create the trust. You know, it's our, my wife, our trust holds our assets. We are the settlers. We create it. We are also the trustees. Now, the trustee or the trustees are the individuals who manage the trust. At the outset, you would be your own trustee. You're going to manage your own assets just like you did before you had a trust. No limitations. You can give, buy, trade, reinvest, anything you want to do. No constraints. It doesn't have to be you. It doesn't have to be me. Everybody names a successor trustee. Who's going to manage the trust if I can't? That's one of the most critical decisions you can make, having the right person lined up to manage the trust for the benefit of the bottom line on the slide here, beneficiaries. So when my wife and I created our trust, we are the settlors. We created it. We are the trustees. We are managing it. We are the beneficiaries. It's all for us. So the real significance of that term, again, is whether it's a revocable or an irrevocable trust, there will be all of these parties, and the beneficiaries are those for whom the trust exists to take care of them. Okay. The trust is the written document. You know, it is sometimes a little on the lengthy side, but necessarily so. Some of the boilerplate language at the end of a trust, you think, oh, why is that even there? Believe me, that can be incredibly important. So yeah, 30, 35 pages. What are you going to do? We have to talk the talk in the trust document. It identifies who is in which of these three roles. So your trust document, which you can amend, that's the written piece of, that's the pieces of paper that describe everything.
Yeah, it's kind of like a contract, with you, yourself, and your family. It's a funny thing, but it's really, really important. Now, I want to spend just a moment on estate taxes. Now, we can't really see all of you, but maybe in your mind, think about what percentage of the population do you think is actually hit with estate taxes? We often hear people lose the family farm because of it. Do you think it's most families or some families or very few families? Think about that. Think about a percentage that you think. Is it 10%? Is it 20%? Is it 50% of American families? Is it 5%? The reality is it's a tiny sliver right now. It's only about 0.1 to 0.2% of estates, about 1 in 1,000. Now, in Silicon Valley, it's a much higher percentage. In prosperous areas and high net worth areas, of course, it's a much bigger percentage than that. But nationwide, it's not a huge issue because the exemption, the amount that you can pass tax-free, is very high. It is currently $12.06 million per person. So for a couple, a married couple, that's over $24 million you can pass free of any estate tax. Next year, because inflation is high, that these numbers are indexed with inflation, it's going to jump to over $12.9 million per person. However, this is not etched in stone, and it can change, and it almost certainly will change on December 31st, 2025, or really, I guess you could say 12:01 a.m., January 1st, 2026, the current law will sunset. The exemption will be cut by 50%. And we'd like to think that the economy will turn around, and before then, your estate will grow. So don't think of this as a $12 million exemption. Hopefully, we're going to be around in a couple of years. Think of it really as a $5 to $6 million exemption, which is what it probably will be in a few years. And depending on what happens in the next few years in the Congress and the Senate and the presidency, it could drop even more. If Democrats controlled all three branches, it's very likely it could drop, but it seems most likely we're going to have a split government. That's why the election was so important. Democrats in charge of the Senate, Republicans in charge of the House, Democrat in charge of the presidency. If any one of those three is split, the law will continue and will sunset in 2025, the end of 2025. This is all important because it relates to your trust structure. And I ask the question, 2AB or not 2AB? That is the question. I'm sorry, I couldn't resist. I'm saying we, it's really me. I apologize for that very lame pun, or I'm not sure how you categorize that. This is a dad joke, I don't know. But that's really what we're talking about, because this goes to, should you have an AB trust or not? And the two key issues we have to pay attention to, capital gains taxes versus estate taxes. So we're going to give you a couple examples to try to walk you through this. And just, and Mike, as we get to the next slide, maybe just spend a moment talking about capital gains taxes and the concept of a stepped up basis, because that's also crucial. And last thing I'll say is we're focusing on taxes here. There are other implications, obviously, to the structure of your trust. This is a focus on tax. So let's go through an AB trust, the stepped up basis, estate tax. Here's an example. So Mike, why don't you take us through that?
So as Mark said, it is important to just revisit and be clear about capital gains tax and the stepped up basis. So simple example, if you buy a share of stock for $10, that's the cost basis. The price you paid for your house, that's the cost basis. If you sell it for more, you have profit or capital gain, and you have to pay capital gains tax on that. So if you bought it and you sell those assets while you're living, you will have capital gains tax exposure. Now, if you own that asset in your estate at the time of your passing, you get the benefit, your estate, your kids get the benefit of this thing called the stepped up basis. And what it means is that the basis increases from, regardless of where it started, it increases to reflect the market value of the asset on the date of death. So in my hypothetical $10 share, if it's worth $25 on the date of death, the basis becomes $25, and the survivor can then, the inheritor can then sell it for $25, subtract the new basis of $25, zero gain, zero tax. So the stepped up basis is incredibly important when you have appreciated assets. So it's one of the, and the reason it's so important in this context is, as you will see, some approaches in the AB trust and the revocable trust allow for a stepped up basis at the second death as well as the first. Both of the structures we're going to talk about allow for a stepped up basis in all assets at the first death. The question is, what about the second? Okay, so now let's go to your traditional AB trust. Until a few years ago, you had to, if you're a couple, you had to use this approach if you wanted to maximize the level of estate tax protection. And, it wasn't that long ago that the level of individual estate tax protection was $1 million. It's hard to imagine. Now it's 12 million. It's so much higher. Back when it was 1 million, you had to do the AB trust as a couple to be able to protect $2 million from the estate tax. If you did a very simple trust, you could blow $1 million worth of protection. So the AB trust was always done with that in mind. So here's what happens. Let's take a look at this flow chart. Here we have an estate worth $6 million. At the first death, and by the way, everything is held in the AB living trust as long as the couple, or as long as they're both living. At the first death, it's going to split into the A and the B trust, the survivor's trust and the exemption trust. An easy way to remember that, by the way, is survivor's trust is A, above ground, B, below ground for the exemption trust. It works, forgive us, okay? So at the first death, remember, we're going to have a stepped up basis and the real property and the stock, everything that's in the estate, stepped up basis. So the survivor could then sell assets without capital gains tax exposure. The estate is going to divide into two trusts, as said. This is a community property trust. $3 million is going to go into each of the trusts. When the $3 million goes into the exemption trust, the first decedent is basically saying, hey, I know I can protect at least that much from estate tax exposure. I want to take advantage of that protection and lock it in. So my $3 million, my half, is going to go into this trust, which, by the way, becomes irrevocable at that point in time. The survivor can't change who inherits, but the trust is there for the benefit of the survivor. All the income flows to the survivor. If she needs the underlying assets, she can reach them. So it isn't like the money is unreachable. It's just that it's in an irrevocable trust. The point there being that when that $1 million goes in, that money is permanently removed from the survivor's estate. So if the assets in that $3 million trust triple and they're worth $10 million at the time of the second death, no estate tax, right? Because they're not in the survivor's estate. They've already utilized the level of estate tax protection that lets that $3 million pass without tax. Okay, that's good, especially if that asset is going to grow. The survivor's trust holds the other half. The survivor can change that any way he or she wishes. That $3 million plus any growth will be in the estate of the survivor. Now, remember, it's got to be in the estate to get a stepped up basis. So assets in the survivor's trust, they get another stepped up basis at the second death because they're in the survivor's estate. The assets in the exemption trust, they're not in the survivor's estate. There is not a second stepped up basis. So after the first death, when we work with the survivor, with the trustee to decide which assets go into which trust, we do our best to pull out a crystal ball. If we have an asset that we think is going to grow in value, but they're still not going to have a taxable estate because they're under the limit, we want that to be in the survivor's trust, right? Because we want to get a second stepped up basis. If we think the estate could grow to the point where there could be estate tax exposure, we want that same asset in the exemption trust because that's removed from the survivor's taxable estate. So these are the things we think about as we assess the value and benefit of the AB trust, as we think about estate tax, capital gains tax. And you'll see, by the way, at the second death, the assets don't go to the kids, they go to family protection trust, the irrevocable trust that Mark will revisit later on. That's your standard traditional AB trust.
That's a lot. Let's go to an alternative structure.
Okay, so this is, we call it a continuing couples trust. It's a trust that does not divide into two trusts after the first death. Now, the change in law that is so important here is that whereas before this change in law, we had to use the AB trust, so we could use each spouse's maximum level of estate tax protection. Currently, by the way, as Mark said, that's 12 million each, that's 24 million. If you didn't do that, you would only have one person's protection, currently 12 million. I'm still an awful, it's a lot. Okay. The change in law allowed for something called portability. And basically it says this, that even if you don't do this split, even if you keep it in one trust where the survivor is going to be in complete control, we can still capture the first decedent's level of estate tax protection. We have to do some filings with the IRS. We have to do the correct paperwork, but we can still capture that benefit. So let's go to that $6 million estate. Here, we're not going to have the division, right? Because we're going to keep it all in one trust. The survivor is in complete control of the trust. So one difference is that now the survivor actually has the opportunity to change the inheritance or bequest plan. Whereas with the AB trust, remember, one sub-trust, that belonging to the first one who died, that becomes irrevocable. So the survivor can't change that distribution plan, okay? The assets in this estate at the second death, again, even though we've really set aside $3 million as protected from estate tax, everything is going to get a second stepped up basis, which is an argument in many cases, not all, in many cases, for taking this approach because we want to be sure we get this second stepped up basis. The assets ultimately are still going to go into the two Dynasty trusts for the two kids. That makes all the sense in the world. So when we sit down with somebody, a little data, we've done, between 1,000 and 2,000 AB trusts. Many of our clients have come in to ask the question in light of this change in law that we have publicized to our clients. We've educated our clients about it. Should I keep the AB trust or should I shift? Should I do this? I kind of like this idea because then the survivor controls everything and there's no other trust to manage. A lot of people like what seems like simplicity. So there's about 5 or 6 elements to the equation, things that we think about with you to decide which trust approach makes the most sense. No one approach is a no-brainer.
And as Mike just went through this, it's a lot. It took me a couple years of acting as an attorney in this space to really grasp all this. So it's okay if you couldn't follow this. And we'll talk about family protection trust. It doesn't have to go to family protection trust after you pass away. We think that's a best practice. But let's go through some high-level ways to think about this because it is a lot and laws change. So capital gains taxes, if you have a house, this is the most classic example we see all the time. If you have a house you bought a long time ago, if you paid under $100,000 for your house in the Bay Area, we have to be aware of capital gains taxes. You have to make sure you get that stepped up basis. Broadly speaking, from a tax standpoint, if your total estate is under $5 million as a couple, we think from a tax standpoint, a non-AB structure is probably best. Now, if you're okay with your spouse having full control after you're gone, because you eliminate capital gains taxes, and if it's under 5 million, we're not too concerned about estate taxes. But we have to, again, I'm just going to reiterate, we have a split government. It's a very, very high likelihood that we're going to have that sunset. The exemption is going to drop by 50% for estate taxes at the end of 2025, meaning that if your estate is even close to what we think the future estate tax exemption is going to be, you probably want an AB trust. So just from a tax standpoint, that's how I would think about it. Smaller estate, appreciated assets, non-AB. Larger estate or an estate that's growing, AB trust. Let's go to the mysteries that we talked about.
Mark, excuse me. Before that, I actually have to go. I am summoned. Before I just say goodbye to everybody and thank you.
I'm going to keep it going, so don't go anywhere, people.
Yeah, Mark's not going anywhere. We focused on the AB trust or not the AB trust for a married couple. There really are other revocable trusts. A single person, you do a revocable trust. There's no AB trust to think about, right? There's also what is generically referred to as an ABC trust. It's a different animal. It's not that common, so we didn't spend time on it. There's something called a QDOT if one spouse is a non-citizen. So we're very aware there are other types of revocable trusts, but again, this is the high level for the couple. That's what makes the most sense, and that's the focus here. So with that, we welcome you to come visit us. Mark will talk about that a little bit later. Thank you, Mark, for carrying on.
Yes, so let's keep going. Yes, sir, let's reveal that mystery. So again, Larry and Susan have a $3 million estate. Susan outlives Larry by 5 years. Their children face $300,000 in capital gains taxes when they inherit. Wyatt and Jane also have a $3 million estate. Their kids face 0 in capital gains tax exposure, not TA exposure. Sorry about that. When they inherit, what's the mystery? Well, simply Larry and Susan had an AB trust. So their assets split when the first spouse passed away. And when Susan passed away, Larry's half of the estate held in that B trust below ground didn't get a step up in basis, and the value of the assets in that trust had grown between the time that Larry and Susan passed away. His kids face a $300,000 capital gains tax bill if they sell those assets. Wyatt and Jane simplified. They said, hey, we're not worried about estate taxes. We like the simplicity of a non-AB structure. Their estate benefited from full step up in cost basis when the first spouse passes away, and another full step up in cost basis when the second spouse passed away, meaning that there was no capital gains tax exposure for their kids. That's the big picture. So let's go to the next example, Ben and Ann. So Ben and Ann have a very large estate, $10 million today. By the time that they pass away, the estate's grown to $16 million. When they pass away, though, their kids face, or their estate faces, over $1 million in estate tax exposure. Jacob and Sarah also have a $10 million estate. It also grows to 16, or actually I think it was 18 million. Sorry for the little thing. But let's say it grows to 16 or $18 million. When they pass away, their estate faces 0 estate tax exposure. Why? Because Ben and Ann didn't use an AB structure. So growth in their estate wasn't taken out of the estate tax regime. The non-AB trust was the wrong choice for them. They unnecessarily faced over $1 million in estate taxes. Jacob and Sarah use an AB trust. So even after the exemption dropped, they had taken a big portion of their estate out of the estate tax regime using that B trust, saved $1 million. So again, the details of this don't matter so much. There's a lot that can change, but this is just to illustrate. Again, slightly smaller estate, you would probably look at the non-AB trust, or simplifying it if you have one. And if you're not sure, talk to us. We can very quickly help you to understand that. Broadly speaking, these are not etched in stone. These will change over time. This changes depending on your situation. When you're thinking about this, if your full estate is under $5 million, that's the majority of us, then you probably don't want an AB trust, at least as it relates to tax issues. This means you have to be okay with the idea that after I'm gone, my spouse has the ability to fully change everything, because nothing becomes irrevocable after you pass away. From a tax standpoint, a non-AB trust is generally the right one for a smaller estate. If your estate's over $8 million, an AB trust is almost certainly the right call, because the estate tax exemption is going to drop. Your estate's probably going to grow. We want to be conservative about avoiding estate taxes. We can help you look at this. By the way, it's not all about taxes. We're not spending much time on that here today, but even if you have a smaller estate, smaller is a relative term in California, right? Only 5 million. That's small. No, it's big, but in the context of estate taxes, it's small. Um, but if you're in a second marriage, or if you have kids from before your marriage, that's where you still might want to think about an AB trust. We have couples who got married later in life. They have a lot of separate assets, and they just want to be sure that their wishes will be followed, even if they go first. So there are situations where even if you don't have a huge estate, an AB trust is right. So this is all about taxes, right? So there's another benefit of the fact that that B trust locks your wishes into place if you pass away first. So you want to make sure that your kids get a share of your estate, even if you married in a second marriage where there's other kids. That's a very common situation where one spouse will want to make sure that their kids get something when they're gone, even if they go first. Bottom line is, let us look at your trust and your situation. We can help you to figure this out, what the right choice is. Now, what if you are the survivor, a widow or a widower, and you lost your spouse many years ago and you had that AB trust? We've helped many families where we had a couple a few months ago where the husband passed away in 2002. The wife is still around. Their Palo Alto house was in the B trust. The house was worth under $1 million when it was put in that exemption trust. It's now worth over $3 million. Their family was facing hundreds of thousands of dollars in capital gains taxes when it went from mom to the kids, because again, that B trust doesn't get the stepped up basis. We help them go to court to undo that B trust. If everybody in the family is on the same page, we can often undo it and save hundreds of thousands in capital gains taxes. So even if you think it's too late, oh my gosh, my spouse passed away a few years ago, I don't like the idea of this AB that we have, we can often undo it. So big picture, if you created your trust many years ago, as Mike said, we've done thousands of these, it is very likely an AB trust. Not always, but almost very, very commonly AB. If you're confused or overwhelmed about all of this, talk to us. There's no way we can break this down in super simple terms. And I know we've gone through a lot of tax issues, but we can help you understand the complications and implications of your situation and what the structure is right for you. I want to flag that we haven't really talked about this. We talked about capital gains and estate taxes. We have to be aware of property taxes. We've done a lot of talks. If you followed us, we talk a lot about Prop 19. It is a huge change in California law as it relates to properties. If you have properties you've owned for a long time, a home, a rental property, a cabin, you need to be aware of the fact that without planning, property taxes could go up 100%, 500%, 1,000% when the properties go from you to your kids, because Prop 19 eliminated most multi-generational protections for property taxes, that your properties will largely get reassessed when you pass away unless you plan ahead. So we have a webinar on that, the end of Prop 13 and preserving low property taxes. It's in our Gilfix Law YouTube channel. If you're concerned about this sort of relates to your trust structure, but there's some other tools we can use there. So we have a lot of tax issues to be aware of. We can help you navigate it. Now, let's just go through what revocable trusts don't do and what you can do to add in some additional protections. They don't protect you from divorce or from lawsuits. They don't protect you from all estate taxes. The structure can have implications for that. And as I talked about just now, they don't protect you from property taxes. Again, incomplete estate tax protection, long-term care. A lot of people think, well, if I have my assets in a living trust, I can get more benefits and they'll pay for nursing home care. It's not the case. There are different structures we can use, but if you need expensive long-term care, a revocable living trust doesn't protect your assets to preserve government benefits. And revocable living trusts don't protect assets for multiple generations. Again, don't protect from massive property tax increases. So what are the issues in your trust and other trusts you might create in the structure there for the next generation? Well, first off, I have to flag that if you have a child with a disability, and disability is a broad term, it can mean legally speaking, it just means the inability to maintain gainful employment. It could be a child on the autism spectrum, a child with a substance abuse issue, a child with mental illness, a child with a physical disability. Critical to set up a special needs trust for them. So at the end of that AB trust or non-AB trust, assets should not go to your child. They should go to a special needs trust. We wrote a book on this. Mike and I co-authored Special Needs Trust Creation and Management Guide. It's available on Amazon. It's available to our clients for free if you work with us. We have a lot of webinars on our Gilfix Law YouTube channel about special needs planning, but you have to be aware of this. If there's someone in your life who has a child with a disability, if it's not you, let them know they need to be aware of special needs trust. We can, of course, help with that. Now, let's say you have children without disability issues and you just want to protect assets for your kids and your grandkids and your great-grandkids. Well, what can you do? How can you supercharge your planning, taking it from the valley floor to the mountaintops? Well, there's a tool for that. There's a lot in the media about our version of these are family protection trusts, but they're generically known as Dynasty trusts. Now, when you picture the term Dynasty trust, you may have an image like this in your head. Dynastic wealth and mansions and all that. Although, as I like to point out, a mansion in Ohio might be less expensive than a single family 3-bedroom, 2-bath home in Silicon Valley, which is absurd. It's all relative, right? But a lot of people think, well, Dynasty trust, family protection trust, that's not for me. That's really only for multi-generational billionaire families. I shouldn't be thinking about that. I would say you should, because there's no reason that only ultra high net worth families should be able to protect their kids in case they face issues. Now, so we talked before about, again, the AB trust and the non-AB. In our illustrations, we said, let's say you have 2 kids, we don't recommend that you leave assets to your kids. Instead, we recommend that you leave them to family protection trusts. So if you have 2 kids, that'd be 2 family protection trusts. If you had 1, it would be 1. If you had 3, it'd be 3 family protection trusts. Why would you do that? Well, if you leave assets directly to your child and they get married and they commingle assets and they get divorced, goodbye to half of what you left them. If you leave it to a family protection trust, the assets you leave to your child remain separate. They shouldn't be lost in a divorce settlement. Second, if your child is ever sued, car accident, if they're a doctor, they have their own business, they can face a lot of liability. If they inherit assets directly, there's no protection. If you create a family protection trust for them, there's a barrier. It's much harder for someone to reach those assets in a lawsuit. Third, when your child passes away, and this is huge, you're thinking a generation, 2 generations ahead. When your child passes away, if they inherit assets directly, it's all part of their taxable estate. So the growth of those assets are added to whatever your child earns to be exposed to the 40 or 50% estate tax. We don't know what the estate tax is going to be like in 10, 20, 30 years, but it's very possible it could be much more strict than it is today. If you leave it to a family protection trust, largely speaking, those assets are not part of your child's estate, and they, plus all the growth during your child's life, extend and they go to your grandchildren, your future grandchildren, free of estate tax exposure. And these trusts last for multiple generations, by the way. And you might think, well, this is great. I like the idea of protecting against divorce and lawsuits and future estate taxes, but I don't want to tie my kids' hands. I don't like the idea of an irrevocable trust, and these are irrevocable, tying my kids' hands. Well, if you think your kids are responsible, they can be in charge of their own trusts after you're gone, giving them wide discretion and authority to use the trust funds as they see fit. They can buy a house with it. They can use it to support their family. There are many restrictions about it. So it's kind of like having your cake and eating it too. And asset protection, but still giving your kids flexibility. And they last for about 100 years in California. So it's divorce and lawsuit protection, not just for your kids, but for your grandkids or future grandkids, and even for your future great grandkids. It should not be, I am passionate about this, it should not only be for the ultra high net worth. Ultra high net worth families have been doing this for a very long time. I think every family should have the option of adding these to their plan to protect their assets. Whether you have a $1 million estate or a 10 million or higher, these make sense. So I'd say the majority of our clients end up adding family protection trusts for their kids. So let's circle back to that mystery, the tale of supercharging a plan, Larry versus Wyatt. Each of them gets $2 million in inheritance. Both of them endure divorce and lawsuits. When Larry passes away, zero of that $2 million inheritance there, because half of it was lost in his divorce. The rest of it was lost in the lawsuit. Wyatt, on the other hand, $6 million left. And when his kids passed away, 18 million. Why? Because Wyatt's father created a family protection trust. So when Wyatt endured a divorce, the $2 million was not touched and was able to grow during his life. And when he was hit with a lawsuit, the people suing him said, we don't want to touch an irrevocable trust. We're not going to go after that. So he didn't lose it there either. And his assets grew, went to his kids. They were protected from divorce and lawsuits. It grew during their lives, untouched by estate taxes, goes to the grandkids. And it literally can be $18 million difference, even if you're not starting out with that much. That's what's so crazy when we look at multiple generations. So we are passionate about at least letting let families know about this option. And we talk about it a lot. I know you're probably sick of it if you watch a lot of our talks, but we strongly believe that everybody should have these trusts in place. Just want to circle back. If you have a very large estate, if you're over 10 million, over 15 million, a lot of our clients are in that category. We wrote a book, Beat Estate Tax Forever, that goes into specific strategies about that. We did a webinar, Estate Planning for High Net Worth Families, on our YouTube channel. Most importantly, meet with us. There are a lot of tools we can use aside from your trust structure to limit tax exposure. Now, I want to wrap this up and tie it all together for you. There's a lot we went through here today. This is probably one of our more complicated webinars because it does involve a lot of issues. What can you do to protect your family and to preserve your hard-earned legacy? And I'd say the first thing, it's not legal, it's psychological. Overcome what I like to call the 3Ds, the danger of delay and denial. Your kids won't ever get divorced. I'm not worried about this. I'll get to it later. Or as I hear a lot of clients in my meetings say, well, if I die, then I hate to say it, but it's going to happen. I mean, if you discover the secret to immortality, please let us know. I'd love to be in that business. Although if you look at ancient tales about immortality, it may not be all it's cracked up to be. But as far as I know, we're all eventually going to kick the bucket. So we have to address this. And why not embrace it as a chance to bring your family together and to protect what you have rather than shunning it and kicking the can down the road? So, and a lot of people think, well, I already have an estate plan. I don't need to think about it. Well, as we talked about it, if it's been a number of years since you set up your trust and your plan, altering the structure of your trust could save hundreds of thousands of dollars or more. Or I don't want to deal with a lawyer, it'll be fine. Well, I can tell you, if you don't deal with a lawyer now, your family's going to be dealing with a lot more lawyers later, unfortunately. So we want to help so you can proactively plan and make sure that you address these issues. And broadly speaking, if you're just confused or overwhelmed by all of this, and it was a lot, I get it. We welcome you to join our client community. If you're an existing client, talk to us. We can revisit your plan if it's been a few years. We can, of course, if you have a plan that was set up by another firm years ago, we can, of course, review it and help you to look at it and very quickly break it down and say, is this the right structure? Is it not? What should we add? What should we change? We can very efficiently help you. So contact us at 650-493-8070, Gilfix.com. You can easily find us, or Gilfix.com/myneeds, where you can kind of fill out a little more detail about what you're looking for. That was a lot, guys. So let's all take a breath. And I think the main point, we live and breathe this. We do it every day. So all these things we were talking about, again, it took me a while to really grasp the AB versus the non-AB structure, capital gains taxes versus estate taxes. And now in California, we have this added issue with Prop 19 and property taxes. The bottom line is we think about this all day, every day. It's kind of lame, actually. I now find myself thinking about this in the shower or on hikes. Like, oh, I guess I'm a lawyer now. But I live and breathe this because I love helping families, and our whole team does. It's not just Mike and I, by the way. We have Renee Conrad, Nick Klingenberg, Francis Lepole, our tax guru. So we have a complete team. We all work together. I'm going to get to some questions in just a second. Please reach out if you have questions. We can help. A lot of stuff here. Subscribe to our YouTube channel, Gilfix Law, if you want to see more free content like this video. If you're watching it on YouTube, we're going to post it there. Follow us. We are here to offer information. If this didn't necessarily all apply to you, but there's someone in your life who it does apply to, your parents, your grandparents, your friend, let them know. Knowledge is power, and we would love to get the chance to help you. And I'd just like to, before I get to a couple questions, I just like this idea. We live in such uncertain times. Take control of your future. Embrace this as an opportunity to bring your family together. Estate planning doesn't have to be dark and something you put in the corner and don't discuss. It's a way that you can really actually bring your family together. We want to give you the power to live your life your way. Like, help us. We can help you to take care of the details and the legal stuff so you don't have to think about it anymore.